Order! Order! Welcome to the Tax Prof Court. In this video, we'll be focusing on judicial source of tax law and looking at some discussion problems. Now, I have a video that introduces judicial source of tax law, and it's very, very important that you watch that video first. This video is meant to further expand your knowledge of judicial source of tax law by looking at some discussion problems. Okay, let's go ahead and jump into those discussion problems. We have 47 different discussion problems. Let's go ahead and start with question 1. Who can initiate a court case that deals with a tax matter, the taxpayer or the IRS? So the best way to analyze this question is to think about the levels of court, the trial court, and the three different trial courts where a tax case can start at. Those are going to be the U.S. Tax Court, the U.S. District Court, and the U.S. Court of Claims. The U.S. Court of Claims. So the idea here is we're going to look at each of these cases, these different courts, and determine which of the parties, the IRS or taxpayer, can initiate the actual case. So in the U.S. District and the U.S. Court of Claims, so the U.S. District Courts and the U.S. Court of Claims, both of those, the taxpayer has to pay the tax. So taxpayer has to pay the tax and then sue for a refund. So taxpayer has to pay the tax, the deficiency that the IRS has levied on the respective taxpayer. So the taxpayer has to pay that, and then the taxpayer sues for a refund. So in those two cases, only the taxpayer can initiate the case. But in the U.S. Tax Court, while the taxpayer is always the petitioner, the case can be initiated or can be initiated by either the taxpayer or the IRS. And the reason why is because in the procedural, the way that a tax deficiency ends up in court is through the 90-day letter, and if no action is taken, then the IRS can go to tax court to levy on the taxpayer, whether they have that ability to go to court, and then the court can rule in the IRS's favor. So it can be the taxpayer or the IRS, because the tax court can hear levy decisions as well as substantive tax decisions or procedural tax decisions as well. So actually the answer here is both parties, but remember, only the U.S. Tax Court can be the taxpayer or the IRS. The U.S. District Court, U.S. Court of Claims, only the taxpayer can initiate. Okay, let's go to question 2. Explain the general organization of the federal court system for cases concerning federal tax issues. All right, so in the judicial source of tax law, the intro video, you saw a diagram. I'm going to use the same diagram, and it actually is a similar diagram to what we just did in number 1 where we started. I'm going to start by labeling the three trial courts. And remember that the U.S. Tax Court actually is broken into two types, the regular and small claims. So here, we're going to have the trial court, which is the court of original jurisdiction, meaning that's where they're going to start. And there's really 3 different courts, 4 potential options where a taxpayer can start the claim. So we have the U.S., we're going to start with the U.S. Court of Claims. We're going to go in reverse order as what you see above. U.S. Court of Claims, then the U.S. District Court, U.S. District Court, and then the last type of court is the tax court, but the tax court is broken into the regular tax court and then the small claims. So we have U.S. Tax Court. I'm going to put regular in parentheses after, and then we have the small claims tax court. So that is a trial court. I'm going to do that in black. All right. Now we have appeals. We're going to see where these appeal. Actually, let me change the color on that. Let's do blue. We'll do blue for this one. So appeals will be in blue. So the appeals court. Remember that as a right, almost all cases in the U.S., taxpayer or the parties have a right to appeal, at least one appeal, at least to be considered. Okay? Be considered. So that first level appeals, I should say first level, or the first level appeals. For the small claims, there's no right. You give that up. There's no appeal allowed. That decision is binding on the taxpayer. There's no appeal allowed. That's one of the things that you give up when you consider the U.S. tax court versus small claims tax court. We'll talk about that in a later question. The U.S. District Court and the U.S. tax court, the regular, not the small claims, they appeal to the U.S. Circuit Court of Appeals, and they do so based on the geographic location that the taxpayer resides, where the taxpayer resides. And at the time of this video, and we're going to see this in later questions, there's 11 different numbered geographic circuits, and then there's a DC, so there's really 12. There's 12 geographic circuits. In the future, that could change, so remember to keep that in mind. This video is to give you general idea and general discussion, but at the time of this video, that is the case. U.S. Court of Claims appeals to the U.S. Circuit Court of Appeals, but there's only one that appeals to, and it's the one that's designated for the U.S. Court of Claims, the U.S. Circuit Court of Appeals, so I'll just abbreviate that, for the Federal Circuit. And then both of these, or all of these U.S. Court of Appeals, they all appeal to the final level and the highest law of the land. You got it. Actually, let's change that color. Let's do red on this one. But continue with that discussion. The U.S. Circuit Court of Appeals, they appeal up to the highest court of the land, which is the second level and final, second level appeals. And that is the Supreme Court of the United States, also known as SCOTUS, Supreme Court of the United States. Now, Supreme Court of the United States does not have to hear an appeals. Again, first level appeals, U.S. Circuit Court of Appeals, they must at least consider the decision of the lower court. That's a requirement, unless it's small claims tax court. So that's the idea. All right, let's go on to question 3 now. So that answers that question, the general organization. We start with the trial court, then you go to the first level appeals unless you're small claims because you're stuck at the trial court decision. And then you potentially can appeal to the Supreme Court if 4 of the justices, they grant cert. Okay, at least 4 of them consider hearing the case. Let's go to question 3 now. May a taxpayer take his or her tax case directly to the Supreme Court? No. And the reason why is because all tax cases have to start here at the trial court. They have to start at the trial court. There's no way around that. So start at the trial court. So your options are one of these 4. That's the only place it can start. To get to the Supreme Court, you got to start the trial court. You got to appeal to the Circuit Court of Appeals. Then you got to go to Supreme Court. And again, the Supreme Court is not required to hear your case. So it must start the trial court. Okay, question 4. Who has the burden of proof in most cases involving the tax law and why? So in most cases involving issues of tax law, the taxpayer has the burden of proof. That's very important to understand. The taxpayer has the burden of proof in most cases. Now, why? The burden of proof is placed in the code by statute. And I talked about that in the judicial source of tax law. You can see that. That's the reason why, because the Internal Revenue Code sets the requirement. So Congress. Now, there are some exceptions. There are exceptions to certain areas dealing with fraud, criminal tax issues, penalties, where the courts consider penalties. The IRS then has the burden. Certain substantive issues of law, such as the accumulated earnings tax, golden parachutes. There's certain hobby losses, things like that. There's a few areas, but for most part, almost all issues, the burden is on the taxpayer, not the IRS. IRS does have the burden in a few areas that are provided by statute. Now, the idea here, if many of you've watched shows like Law and Order, or you've seen legal movies where you see the parties, they're arguing, the idea is that the party that has the burden of proof must prove with the preponderance of the evidence that whatever they're trying to assert. In tax, it's okay that as a taxpayer, I should be able to claim a deduction, or I shouldn't have to report this income. That's the idea. The IRS, they don't have to prove that if they don't have the burden of proof. If it gets shifted to them, then through either the statute or because the taxpayer has done a job to show that, then now it goes to the IRS. And if they can't show that, then the court must rule in favor of the party that has either met the burden or did not meet the burden when they need to. That's the idea. That's how court works. Okay, let's go to number 5. The U.S. tax court hears only certain types of cases. Identify those cases. This one's really easy. So it's the U.S. tax court. It only hears federal tax issues. Doesn't hear state tax issues, only hears federal tax issues. Doesn't hear any other U.S. code, only the federal tax, only Title 26. Now, one thing to mention is that it does hear collection cases as well as substantive tax cases or procedural tax cases. It also deals with collection cases. We mentioned that earlier. Okay, question 6. The U.S. tax court has undergone an evolution since it was founded. What happened to its structure in 1926, 1943, and 1969, respectively? So this is one thing I didn't really go in depth on in the introduction to judicial sources. And I plan to do that here because this is meant to be a supplement to that video to help you understand better. Well, we know that 1913, we have our consistent income tax law because of the 16th Amendment. And the idea is that in 1926, the board, so 1926 is our first date on the list, the Board of Tax Appeals, also known as the BTA, if you ever see that in a citation, the Board of Tax Appeals was established. At that time, the Board of Tax Appeals was an administrative board of the Treasury Department. An administrative board of the Treasury Department. Now, here's the idea, is that when it comes to administrative areas of law, such as environmental protection, you've got issues with the Secretary of State, education, defense. Those are administrative areas. When you think of the executive branch, that's administrative law. So what we're talking about are those areas. The idea is that a lot of areas of administrative, before you go to court, you must be heard by a board, an administrative board. So it's a quasi, it's kind of like a judicial system in a way with trying to explain your case and try to prove your points, but it's not the same thing as the judicial branch of government. It's still within the administrative branch. That's the idea, is that at one time, tax cases actually were brought before an administrative board. There really was not a tax-devoted court. Now, when you went to this, you could appeal to the Circuit Court of Appeals and the Supreme Court, but the idea was that from 1926 until 1969, the tax court was not, as we see it today, a separate federal law court. Was not part of the judicial branch, it was part of the administrative branch. Okay? So 1926, Board of Tax Appeals, Administrative Board of Treasury Department. In 1943, let's change the color of the font. Let's change to blue for the next date. Oops, highlighter, my apologies. 1943. In 1943, the BTA changes names to the U.S. Tax Court. It's called the U.S. Tax Court. Now, you're saying, okay, well, now it's like the U.S. Tax Court that we know of today. No, it was still an administrative element. It was an administrative court. So we went from administrative board to administrative court. We're still within the executive branch. It was not a federal court like a federal district court, which is today what it's like. And that's when we get finally to our last date, 1969. I'll do a red font for that. So anything in red deals with this. In 1969, the U.S. Tax Court becomes an Article I court of the Constitution. It becomes a federal court. It becomes a federal court at the same level as the U.S. District Court. Similar level to the U.S. District Court when you're viewing levels like that. Very similar in terms of level. So those are the dates: 1926, 1943, 1969. Okay, let's move on to question 7. How many judges sit on the U.S. Tax Court? What is the length of appointment of each judge? So there's, at the time of this video, and again, this could change in the future. Things change in the future. There are 19 different judges. 19 judges. So that answers the first question. I'll come back and I'll give some more context about the 19 judges. What is the length of appointment of each judge? The length of appointment is 15 years. And the judges are appointed by the president, being advised by the Senate and confirmed by the Senate. So appointed by the President of the United States on Senate, sorry, that's capital S, on Senate advice, and most importantly, confirmation. On Senate confirmation. Now, a few things I want to mention. Those 19 judges, a typical U.S. tax court case, only one judge will hear a case. So normally, one judge hears a case. Normally, one judge hears a case. There are 18 regular tax court judges and one chief judge, and that changes every few years who the chief judge is. It's not something like the Supreme Court where the chief judge is appointed while they're, and they continue until they retire or they change that in some way. That often does change. Now, the chief judge can appoint additional temporary tax court judges to hear cases. We call those magistrate judges. So those are not appointed by the president. And those judges, they can really only hear small claims cases. Federal or the normal U.S. tax court judges can hear small claims cases as well, but the magistrate judges almost always, that's all they hear is the small claims. So I just want to give you some context. So to answer the question, at the time of this video, there's 19, could change in the future. One chief judge. Chief judge can appoint other judges, known as magistrate, but they don't have the full powers as a regular judge, regular tax court judge. And then the length of time of appointment, 15 years each judge, appointed by president on Senate confirmation. And when that their time is up, then either the president can appoint somebody else, they can reappoint that judge, whatever they want to do. All right, question 8. The U.S. Tax Court is a national court that meets in Washington, D.C. Does this mean the taxpayer and his or her attorney must travel to Washington, D.C. to have a case heard? The answer is no. No. Both the U.S. Tax Court and the U.S. Court of Claims, both of them, while they are based in D.C., they are considered riding courts. They ride around the U.S. They ride around the U.S. to major cities such as Miami, Atlanta, New York, the ones you think of. And there's other ones that maybe you wouldn't think of because they want to make sure they have geographic representation for parties. The idea is that they're a riding court and you do not have to go to D.C. Now, you can have your case heard technically in D.C. if you reside in that area. There is a court in D.C., but it's a riding circuit. It goes around, the court goes around, the judges go different places around, and that's a riding circuit, a riding court. Does this mean that the taxpayer and his or her attorney must travel to Washington, D.C. to have a case heard? No. Again, no. The judges are the ones that travel. Question 9. May a taxpayer have a jury trial in a U.S. tax court? No. The only one of any of the courts we're going to talk about today, whether it's a trial court, the appellate court, the Supreme Court, whatever it is, the only court that has a jury, my apologies, the only court that has a jury potentially is the U.S. District Court. Make sure you write that down. The only court that can have a jury trial potentially, and I'm not saying that you are guaranteed to have a jury trial. You can still not have a jury trial in a U.S. District Court. The only one potentially is a U.S. District Court. Number 10, what does the term en banc mean? So in the Judicial Source of Tax Law introduction video, there were a lot of different Latin terms. So this one, en banc, means the sitting of the entire court. So the entire court, if you ever see en banc, the entire court decides a case. That's what it means. And when it comes to tax court cases, I mentioned that there's 19 judges. It's possible that a case can be heard en banc. Usually that's going to be if it's an area of tax that's unusual, important, or a novel issue, so a new issue, then it's likely that the case will be en banc, and that will be in the citation. If you don't see it in the citation, it's not en banc. It's assumed not to be en banc. It has to be in the citation for it to be. If it is en banc, it's stronger than just a regular case that's not en banc, just heard by one judge. The idea is that more judges hear it, the stronger it is, the stronger of authority it is. That's the idea. Question 11. Distinguish among regular, memorandum, and summary decisions of the tax court. So let's first start by regular. I'm going to do that in black. So regular decisions, they generally involve a new, so I'm just going to do this let's just break these out into little sections. So I'll put a little line here, and then we'll do memorandum next, and then summary decision in different colors. So a regular tax court decision. A regular tax court decision deals with a new or unusual area of law or point of law. So new or unusual area of law as determined by the chief judge. And by the way, the en banc question, the last one, question 10, the en banc, this is decided by the chief judge whether a case will be heard en banc. It's decided by a chief judge. Same here. Who determines whether an opinion will be a regular, memorandum, or summary decision? Summary decision, we'll explain that later on, but the difference between regular and memorandum, the chief judge makes that determination. If the chief judge believes that the decision concerns only the application of existing law, then it's going to be a memorandum decision. So I'll write that down. From question 10, en banc is determined by the chief judge. The chief judge makes that determination. A regular tax court decision is binding. It's binding on the tax court unless the Golson rule, which we're going to talk about in the next question. It's binding unless the Golson rule is an issue. And it's determined by the chief judge. So the chief judge makes a decision on which cases will be heard regular. And there's only about 25 to 30 tax court regular opinions each year. Memorandum is next. Let's change our color to blue. So if the chief judge believes that the decision concerns only application of existing law, so it's not a new area of law, application of existing law, so maybe a new set of facts, but application of existing law, then it will be a memorandum decision. It'll be a memorandum decision, and that is binding. Again, subject to the Golson rule, again, which we're going to talk about in question 12. Now, there's about 200 to 300 of these cases per year, memorandums, so there's a lot more than the normal ones. And if you go to the tax court website, you can actually look up their recent opinions and search by a date. And let's just say you put in the last year. You're going to see there's way more tax court memorandum decisions than regular tax court decisions. And finally, in red, and I put red because that's caution, we've got the summary decision. So that's going to be over here. Let's highlight, by the way, in blue the memorandum so you know it's in blue. So in red, we've got the summary decision. Summary decision are issued in cases tried under the small procedure. So the small procedure tax court. And remember, you cannot appeal your small procedure tax court claim. And also, other taxpayers can't rely on it. It's not binding. It's not binding on anybody but the taxpayer. So it can only be used as persuasive evidence like a private letter ruling or something like that. All right, let's go to question 12. Question 12, by the way, I referenced in question 11. So these questions, 10, 11, 12, all go together. Question 12, the U.S. tax court is a national court that hears cases of taxpayers who may appeal to various geographical courts of appeal, right? The U.S. Court of Appeals. How does the tax court reconcile the opposite holdings of two or more of these courts of appeals for taxpayers who work or reside in different parts of the country? That's an excellent question. And that is what's known as the Golson rule. The Golson rule, this was a tax court case. The Golson case was heard back in, I believe, the 70s. And this case basically established the Golson rule, which the courts still follow today, and they still reference this. When confronted with opposite holdings opposite applications of the law and resulting in holdings. The tax court will follow the Court of Appeals holding, if any, that has direct jurisdiction. So we look to the U.S. Circuit Court of Appeals that applies to that taxpayer. Geographically, or if it's, geographically for the U.S. tax court. Geographically, right? If it's the U.S. Court of Claims, then they're only bound by the one circuit, so they don't have this issue. That's the idea. And if you are in the U.S. District Court, well, that district court's bound by that geographic U.S. Court of Appeals, so they don't have to worry about other circuits anyways. So that's what the Golson rule is. It's specific to tax because it's a national circuit, because other tax court cases combine other tax court judges. The idea is that, let's say that Judge Smith, that's a U.S. tax court judge, hears the identical same set of facts in California, which is the 9th Circuit, and in Florida, which is the 11th Circuit. And they hear those different cases 6 months apart. And Judge Smith results in the 9th Circuit applying the 9th Circuit law, because the Golson rule says that the U.S. Circuit Court of Appeals applies to that taxpayer. That's what they have to look at. So the tax court, the U.S. tax court, will look to the U.S. Circuit Court of Appeals that applies to that taxpayer. So if Judge Smith is, let's say Judge Smith is in Los Angeles hearing tax court cases, and there's a taxpayer that resides in California, which the 9th Circuit applies, Judge Smith is bound by the 9th Circuit. However, when Judge Smith goes to Florida 6 months later, same set of facts, and applies to that taxpayer, Judge Smith is now bound by the 11th Circuit and also Supreme Court. And if the 9th Circuit and 11th Circuit result in two different results, then it's possible, this is not as common as you think it is, but it's possible that Judge Smith in the California decision in Los Angeles, where he hears the case, can rule in favor of the taxpayer, and then the 11th Circuit rule in favor of the government because of the application of the circuits of above. They might have different applications of the law. And again, you're bound by that precedent. So that's the idea. That is the idea of the Golson rule, and that is how we deal with this issue. Let's go on to question 13 now. Question 13. What is the small tax case procedure of the U.S. tax court? What is the maximum amount of deficiency that can be the subject of a small tax case hearing? Comment on the trial procedures in the small tax case. Okay, so let's start. We have a few questions here. What is the small tax case procedure of the U.S. tax court? So the tax court has really two courts, the regular tax court, and it has the small case or small procedure tax court. It's similar to a small court of federal claims. So basically the idea is that there's a smaller court than the regular that's designed to be more formal. If you look at your local state court, there's bound to be a small claims division, small claims for smaller amounts. And it's designed to be more informal, much more informal. Designed to be much more informal than a more formal process with evidentiary, items and whatnot. What is the maximum amount of deficiency that can be subject of a small tax case hearing? It depends on when you are watching this, but it could change. At the time of this video, it's $50,000 plus interest for deficiencies and $50,000 plus interest and penalties for collection. It's up to that amount. So it's less than or equal to $50,000. Less than or equal to $50,000. The amount at issue. Interest and the deficiency, if it's just a simple deficiency matter, and interest, the amount at issue, and penalties for collection matters. But this is likely to change in the future, so make sure you check that in the future. Make sure you check that. Comment on the trial procedures in the small tax cases. So I mentioned this earlier. The main one being is it's more informal in terms of the rules of evidence. Another element is this is the only court in terms of tax cases where a party, a taxpayer, can appear pro se, which means they can represent themselves. They don't have to have an attorney or somebody that's authorized to bring cases before the tax court. So they can appear pro se. Finally, one other element is that no appeals are allowed. You cannot appeal. No appeals. You're subject to being bound by a decision if you go this route. So there are benefits and burdens. There's trade-offs for picking a small court decision over a regular court decision. You have to consider those. Question 14. Can tax court summary opinions be cited as precedent? Discuss. They cannot. They cannot be cited as precedent. They are not binding on anyone. They're not binding anywhere. However, they do provide a persuasive aspect, just like a private letter ruling does. It's not binding, as we know, only binding on the party that submitted the request. So you can think of it kind of like a private letter ruling in that sense. It's persuasive in the sense that it does give insight in how the tax court has treated similar tax situations. Let's go on to question 15. Please provide the citation for the following case information. So I have a few of these questions spread throughout the presentation, usually after each discussion of each court. You can see the questions are kind of in a topical order. And these questions are extremely important if you're taking my tax research class, because I will have questions on the exam similar to this. So make sure you do follow this. And spaces, periods, abbreviations, apostrophes, numbers, where you put parentheses, all this stuff makes a big difference in terms of your answer. So let's go ahead and continue reading. Now, some of the way that the question is designed is to test you on certain elements of understanding the judicial system, the judicial cases, what parties are involved. So keep that in mind. There's a lot of different things going on. This is a typical question you might get on an exam if you're not just in my class, but another tax research professor's class, because it's meant to test you on multiple things. The taxpayer's name is Mark E. Schluty. He brought his case before the U.S. tax court. It is a regular tax court case, and the tax court judge issued a formal tax court opinion. One judge heard the case. The opinion starts on page 1271 of volume 32 of the official reporter for that kind of case. The court's decision was made in 1959. Please make sure to put both parties in the citation, and also make sure to use the formal abbreviations for the government party at issue. Also, make sure to properly capitalize certain words that are required to be capitalized, and put all potential words, numbers, apostrophes, spaces, commas, periods, and parentheses in the correct location, as this matters. And it is very important. When you're doing research and practice, you need to make sure that you properly put the citations correctly. There's this thing in legal research, which tax is law, so tax is legal research, that the blue book applies. And if you're ever submitting something before a court, the citation, and they're real sticklers on those issues, you can get called out for those things. Okay, so again, we're trying to provide a citation here. We are providing a citation. Now, before we actually write the citation, let's just go through and discuss. The taxpayer's name is Mark E. Schluty, so we have the taxpayer's name. He brought his case before the U.S. tax court. So we know it's the U.S. tax court. That's going to obviously affect our reporter, the formatting of how we present, all those things. And you need to know the differences in the different trial courts and the Circuit Court of Appeals, as well as the Supreme Court. It is a regular tax court case, so we know it's not a TC summary opinion, right? Because a regular tax court case can be either a TC memo or can be a regular tax opinion. And the tax court judge issued a formal tax court opinion. So that is a regular tax court opinion. It's not a memorandum opinion. It's a formal tax court opinion. One judge heard the case, so we know it's not en banc. We know we can't put en banc in the citation. The opinion starts on page 1271 of volume 32. So that's going to be part of our citation of the official reporter for that kind of case. So now again, we have to think about what the official reporter is for that kind of case. Well, the official reporter for the tax court, formal tax court case, so a regular tax court case, is T period, C period, no spaces like that. T period, C period, that is the official reporter. The court's decision was made in 1959. Okay, well that's important because we're going to have to put that in the citation as well. Please make sure to put both parties. So what I'm saying there is sometimes you'll see tax court cases where they just have the taxpayer's name and they leave out the Internal Revenue Service or the government, because that's one way you can cite. But you're asked here to do both. So, and that's the more formal citation, by the way, you're going to see when you submit to courts and whatnot. So that's very important that you follow that. So we have to put the taxpayer and the government is what it's saying. And also it says to use the formal abbreviation for the government. So if we're dealing with a tax court case, it's going to be Commissioner, COMM''R, no periods. If it's going to be a district court case or U.S. Court of Claims, it's going to be U.S. Just like that. They want the abbreviation. Also make sure to properly capitalize certain words. So taxpayer's name, commissioner, those words. Put all potential words in the proper place. That makes a big difference. Numbers, make sure you put the correct numbers given to you in the proper place. Apostrophes in the proper place. Spaces. And what I'm going to do is I'm going to write out the citation, the correct citation, and we're going to go through it together after reading this, right? We've already read it, now gone through twice. And I'm going to, at the end, in a different color, I'll use red, and I'll put where the spaces are. So you see that because the spaces make a huge difference. Also, again, look at commas, where commas go, periods, because some abbreviations have periods, others don't, and parentheses in the correct locations, those all matter. Makes a big difference. And on my exams, if you're taking my class, they do matter because, again, in practice, if you ever the idea is that a lot of you, even if you're not an attorney, you're going to be working with attorneys, and they might be using those documents to create opinions, and they want those citations correct so they can just copy and paste. They don't want to have to redo all that stuff. It's all about the amount of time that you're spending, and you need to do it from the get-go, from the beginning. So you need to have that same structure. You need to think like an attorney because you're going to be working with attorneys because tax is law. Okay, so again, regular tax court case, TC, T.C is the official reporter. So now we have to think about our citation. And again, we have to have both parties. Remember that we always start in a tax court case with the taxpayer. So the taxpayer here, we use the last name. So we start with S-C-H-L-U-D-E. So Schlude is the last name. Then we put a space. And I'll come back and I'll show you where the spaces are. V. So V, lowercase v, period. Then we do another space. And then it's going to be, because it's asking for the abbreviation of the government party. Because it's a tax court, we know that the Internal Revenue Service, the Commissioner of Internal Revenue, is the other party. Again, if it was a district court case or a U.S. Court of Claims, it'd be the U.S., it'd be the U.S. government. But here it's the Commissioner of Internal Revenue. So it's going to be space, so V period, so lowercase v period, space, C, capital C, O, M, M, apostrophe R, comma, no space, comma. Now we're getting into our numerical citation for where it's located. We do a space, then after the space, we're going to put the volume. It's found in volume 32. So it's going to be comma, space, 32. Then we're going to do another space. This is where the T period, C period, all capitalized, that's this right here. That is the official tax court reporter, the official reporter for that kind of case. And the case is a formal tax court opinion, a regular tax court opinion, not a memorandum, not a summary opinion, regular. Then we do another space and we do the page number. It's on page 1271 where it starts. So page 1271, we do another space, and then we do the year in parentheses. So another space, and then it's 1959. Let me redo that to make it clearer. No spaces in the parentheses, and that is a citation. So now I want to show you where the spaces go, and then we're going to review. So here there's a space between the taxpayer's name and the V. After the dot and the V, there is a space between the V versus and commissioner. And by the way, with tax court cases, it's always taxpayer versus commissioner, just like that. And if I ask you for the formal abbreviation, that's what you would do. Space after the comma, space after the volume, space after the last period in TC, space after the page, and that's it. So anywhere where you see the little red or the little underline, those are actually spaces. You wouldn't put those in the official citation, but I'm showing you where the spaces are so you have that. And this is exactly where the periods go, everything. So again, let's just review. Schluty is the name of the taxpayer, space, lowercase v, period. Again, capitalization and periods and location and spacing all makes a big difference. So lowercase v, period, space, capital and C, O, M, M, apostrophe R, comma, space, volume 32, space, TC, which is the official report for tax court with the periods, space, page number where it starts, 1271, space, year it's decided. Year the court made the decision, and that is the citation. That is the citation. All right. So once you do that, and I recommend going and pulling up other tax court cases, other tax court official cases, find the official citation, because if you're taking my class, I only ask about the official reporters. So the official reporter for a regular tax court case is the T period C period. And you can do more practice. There's pretty much infinite practice, and it's not really infinite, but there's thousands of cases. Just go on to, just go to another tax court, look up this tax court opinion, and then within it, you're going to find other citations to other tax court cases that you can try to practice on. But that is the official citation that we use in the Blue Book, which is the standard that we use for citation. Let's go to question 16. So it's another citation question. Please provide the citation for the following case information. The taxpayer's name is David Shira. He brought his case before the U.S. Tax Court. So far, just like question 15, we're focusing on citation. So far, pretty much same thing. It is a regular tax court case, and the tax court judge issued a memorandum opinion. So far, that's where the main difference is. It's a memorandum opinion. The decision is number 309 of year 1991. Please make sure to properly capitalize certain words and put all potential words, numbers, apostrophes, spaces, commas, periods, and parentheses in the correct location as this matters. Okay, so again, I'm only focused on the official citation. When it comes to the TC memo, you'll notice I didn't ask for the other party because we follow the same format. What we're going to do is we start with the taxpayer's name, David Shira. Now, this is a little different. We do the last name, so C-H-R-I-A, comma, space, David, comma. Then we do another space, T period, C period, space, memo, space, and this is where we do the year, so space, year 1991, and it's the decision number. The decision number is 309, and that's it. So this one's a little bit more straightforward. We're using the official TC memo citation. I give you the information. Let's put our spaces in. So start with the taxpayer's last name, comma, first name, just like that. Do a space, TC, just like we had in the last one, space, memo, then a space after memo, and then 1991-309, no spaces in there. And that is the citation. So last name, first name, Shira, comma, space, David, TC memo, 1991-309, and that is the proper citation. Let's move on now to question 17. Now we're moving to U.S. District Courts. What is the jurisdiction of a U.S. District Court? The district courts hear cases involving legal issues based on the entire U.S. Code and U.S. federal law. That's generally what they apply, what they look at. That is the general area of law they apply. So the idea is that they're much more general than just tax, like we have in the tax court. So that's what the question's getting at, is that you can have any issue in the entire U.S. Code, U.S. federal law. There's other issues that U.S. District Courts will hear as well, But that's almost all of that. But the idea is that, hey, it's way more general than tax. The judges are generalists. They cover so many more issues. Bankruptcy issues, criminal issues, fraud, tax, just so many different things. Patent law, so many different things. Okay? Really the patent cases, though, are in the U.S. Court of Claims. But again, U.S. law, applying U.S. law. Question 18. Is a federal district court a national court? How many judges hear a case brought before a federal district court? So unlike the tax court and the U.S. Court of Claims, so unlike the tax court and the U.S. Court of Claims, district courts, federal district courts they're not national courts, meaning that they don't apply all around nationally. So they're not national courts. They are subject to different districts. And right now, at the time of this video, and this is likely to change in the future, there are 94 districts in the U.S. Many states have 1 or 2. Some states have 3 or 4 districts. Obviously, the states with a higher population. So I'm in the state of Florida. And at the time of this video, there's 3 districts in Florida. There's the Northern District, the Middle District, and the Southern District of Florida. There's 94 districts at the time of this video. That's likely to change. That can likely go up with population increases and whatnot. A lot of states do have 1 or 2 districts. Some states, it's the entire state. Okay, obviously those states are like with less population, like the state of Wyoming. That's the idea. So 94 different districts. And the idea is that a U.S. federal district court is that respective district. So if it's the Southern District of Florida, that is the district. It is not that district hears cases all over the country like the tax court or U.S. Court of Claims, which are based in D.C., but they ride around to all the different circuits and they're bound by each other's law. Now, the districts appeal up to their geographic circuit, and the circuit is made up of multiple states, so there's a lot of districts and then within a circuit. So they're bound by the U.S. circuit, but districts are not bound by other districts. Versus a tax court cases are bound by other tax court cases subject to the Golson rule. Or the U.S. Court of Claims are bound by other U.S. Court of Claims cases. That's the idea. So that's really what this question is getting at. Is it a federal district court? Is a federal district court a national court? No, it's not a national court. How many judges hear a case brought before a district court? 1. 1 judge would hear a case. So 1 judge will hear a case, and the idea is that you're not going to have en banc. So one judge hears a case. You're not going to have en banc potential like you are with the tax court or the U.S. Court of Claims or even with the appeals courts where they can be heard en banc as well. So 1 judge will hear a case. Question 19, please provide the citation for the following case information. All right. So let's get ready. One of your favorite questions, right? Not right. But once you get the hang of this, it gets a lot easier. And again, it's also something you can really practice because you can find another case that we'll be finding here, and you can practice your citation skills. But again, if you're taking my class, very important because I will ask you questions, and you are going to have to cite this. You are going to have to cite different cases, and you're going to have to follow this. So these are very, very important. So please practice this multiple times. Let's go ahead and read the information. The taxpayer's name is Howard Burns. He paid the tax deficiency. Okay, paid tax deficiency, that's important. And brought his case before the U.S. District Court for the Northern District of Ohio. So remember that tax court, you don't have to pay to play. But U.S. District Court and the U.S. Court of Claims, you must pay to play. You must pay the deficiency and then sue for refund. So we're told that he paid the deficiency and he's suing for a refund in the U.S. District Court for the Northern District of Ohio. The opinion starts on page 203 of volume 174 of the first edition of the official reporter for that kind of case. The court's decision was made in 1959. Please make sure to put both parties in the citation and also make sure to use the formal abbreviations for the government party at issue. Also, make sure to properly capitalize certain words and put all potential words, numbers, apostrophes, spaces, commas, periods, and parentheses in the correct location as this matters. And it will matter if you're one of my students. And if you're not one of my students, it's going to matter for practice, especially if you're citing, you're submitting stuff before courts. The district court citation to use in this citation is as follows. So I will tell you, if you're taking my class, that I will give you the district court citation because there's 94 different districts at the time of this video, and that will change in the future. And there's specific citations for those districts. Like, for example, the Southern District of New York is S period, D period, N period, Y period. You might abbreviate that differently, but I'm giving you the official one. So here for the Northern District of Ohio, it's N period, D period, space, the word Ohio capitalized. So that is what we're going to use in our citation. Okay, let's go ahead. Let's go through our citation. And again, what I'm going to do is we're actually going to write it out starting from the beginning all the way to the end. Best way for you to learn this. And then we're going to, at the end, we're going to review it and then put our spaces to make sure that we solidify the spaces because those are important. So first thing, it tells us that, let's just review the facts again. The taxpayer's name is Howard Burns. It's in a U.S. District Court for Northern District of Ohio. Okay, so we know it's a district court case. The opinion starts on page 203 of volume 174 of the first edition, that's important, of the official reporter of that kind of case. So a U.S. District Court case, first edition of that type of reporter. The court's decision was made in 1959. Please make sure to put both parties in the citation and also make sure the formal abbreviations for the government party are at issue. So we're going to need a plaintiff and a defendant. We're going to need both the plaintiff and the defendant. So the plaintiff, who is the plaintiff in this party? It's the taxpayer because they are suing the government. They paid the tax and they're suing. By the way, for the tax citation, the tax court citation, remember that it's not plaintiff and defendant, it's petitioner and respondent. The petitioner is always the taxpayer and the respondent is always the IRS, and that's why we put those in that order. So here we have plaintiff versus defendant. So let's go ahead and do that. So plaintiff here is the last name of the taxpayer. So that's going to be Burns. So Burns. Let me draw that S a little better. There we go. Burns. Then we do a space. And again, spacing is important. Space, lowercase v for our verses, period, space. Okay. So it's telling us to a formal abbreviation of the government party at issue. Because this is a district court case, District Court and U.S. Court of Claims, we're suing the U.S. government, so it's U period, S period. Then we're going to do a comma. We're going to do a comma next. No space, just a comma. Then we do a space. And we do the volume number. So a space, volume number. The volume number here is 174. So let's put 174. Space. Now we need a reporter. So it's the first edition of the official reporter for the U.S. District Court. Now, some of you out there, you might know the history of U.S. District Court cases, and a long time ago there was different reporters, but I'm talking about the ones that are in the modern era, and that is going to be the Federal Supplement Series. The Federal Supplement Series, F period, S period, with space right there. So there's a space there. Let me rewrite that. We erase and rewrite so you have it down. But this is the Federal Supplement Series. The modern era is what I'm going to be testing on for those of you in my class. So it's F period space sup. S-U-P-P, not like what's up, but sup, supplement, period. And one thing to note is that if you are in the second edition, it would be F period space S period, S-U-P-P period. Then you do another space, and then second edition is 2D. Third edition is 3D. If it's a fourth edition, which at the time of this video, there isn't a fourth edition, but likely on the horizon, it'd be 4D, no period, just like that. Okay? That is how you would cite that, just so you know. Let me erase, give me some room there to continue our citation. Again, that is the official, that's the way that you reference the federal supplement, like that. So here, we're the first edition, so we are this one. We're not the second or third. So it's going to be 174 space F period space sup. S-U-P-P period space the page. It starts on page 203. It's a page it starts. So space page 203. Now we need another space. And this is where we have our location as well as our year. So space, and then we have our location and year. Let me put a line here. So we're doing the official citation down here. So space. Now we have our location. That's going to be this right here. So it's just N period D period, and follow exactly how as I give you. Space. So N period D period space. Capital O for Ohio. HO. So exactly how I give you. So if I told you that Southern District of New York was, and I gave you quotation marks, S, capital S period, capital D period, capital N period, capital Y period, and I ended the quotation marks, you would literally copy that. So N period D period space, because there's a space in between the two words in the quotations, capital OHIO space, and then the year it's decided. So it's all about the year it's decided. Decision 1959, so space 1959. Boom. Just like that, we have the citation. So let's just explain what's going on here. Remember, we have the plaintiff and defendant. So Burns is the last name of the taxpayer. So Burns space, lowercase v period, so versus space U.S. We put the U.S., the formal citation as asked to do. U.S. is defendant because, again, taxpayer Howard Burns is suing the government for a refund, comma, space. Now we've got our location of our citation. It's in volume 174, space, federal supplement. And again, there's a space between the F period and the sup period. Then we got our space. 203 is the page number it starts. And then we have our final part of the citation, the location and the year. Northern District, Ohio, space, 1959. So let's put in our spaces, and then we are done with our citation. We have a few more left to do in our problems, but done with this one. So space. And by the way, if you are taking my class, I'm giving you enough time on the exam to go through this. And please take your time and review and make sure that you have this correctly. Make sure the spaces are correct, the capitalization, the numbers, all these things, just like I have in the question. The questions that you're likely to see are very similar to these. So again, you can practice. You can find other district court cases and practice this. I will give you, again, the official citation for the location. I will give you that, what the abbreviation is. So space, got another space here. Another space here, another space here, another space here, and boom, spaces. Oh, got some more in here. One space here, one space there. So we've got all our spaces. So Burns v. U.S. space 174 F sup 203 ND Ohio 1959, and that is the citation. Boom, just like that. And once you do these and you maybe practice a few more, honestly, you get the hang of it. It's just like, it's kind of like when you first started learning tax. It was kind of like you start getting used to certain areas, and this is the same thing. Let's go on to question 20. Differentiate between primary and secondary case citations. So primary citations are the official citators, and those are the ones that I ask. If you're in my class, I ask about the official citators. So for example, we just saw the district court, that would be the F period space supplemental. So federal supplemental series, second and third, I showed you how to do those as well. That would be those. For the tax court case, it would be T period, C period, or tax court memo. We're going to also look at some other ones later on. But those are the official citators. There are some secondary citators that Checkpoint, CCH, Westlaw, Lexis, that they do. I don't worry about those because then you'd have to learn those as well. Also, when you are doing citations, it's best to do the official citation. I mean, there's going to be times where you can't get the official citation because the case is so new. The ones that I'm going to ask you about, those on my exam, if you're taking my class, those ones you're going to be able to do the official. Trust me, you'll be able to do the official. I'll give you all that information. You're not going to have to know how to write out the secondary. But you do need to know that a secondary citation can be used. The idea is that you want to use the most official one unless it's not yet available, and then you want to use a secondary. So that's really what the idea is. So secondary is not the official, but it can be used at times, and you want to always strive to use the official. Let's continue on. Question 21. So now we're moving on to another court. Question 21. What types of cases are heard by the U.S. Court of Federal Claims? So the U.S. Court of Federal Claims hears cases concerning all monetary claims. So all monetary claims that are brought against the federal government. Against the federal government. So these could be issues dealing with contracts with the federal government, obviously taxes, right? It's dealing with the issue of, okay, I paid the tax that the government says I owe, and now I'm suing for that because I think that the government's incorrect. The government is incorrect. So it's all monetary claims brought against the federal government. And only one type involves tax refunds. So there's multiple issues: contract, patent law. Patent cases go before the U.S. Court of Federal Claims. Okay, U.S. Court of Federal Claims. Just so you know, there's many issues. Just like the federal district court, U.S. District Court, it's more general than just tax. Let's go to question 22. How many judges are appointed to the U.S. Court of Federal Claims? So at the time of this video, there's 16. There's 16 judges. Usually one judge will hear a case, but it might be more than one judge. It could be en banc. Could be more than one judge. Okay, could be en banc, just so you know. So 16 judges of the U.S. Court of Federal Claims. That can change in the future, probably will. So make sure you look at that. Again, I'm just showing you what is the time of this video. It's probably not much more than 16 if it's gone up, but 16. Question 23. Is the U.S. Court of Federal Claims a national court? Must the taxpayer go to Washington, D.C. to present a case to this court? We've already kind of gone over this because I kind of answered this when we talked about the tax court and also the district court. The U.S. Court of Federal Claims is a national court, which means that it's the entire country. It's the entire country. It's not just, it's not 94 districts around the U.S. It's one, think of it as like one district court. It's a national court. That's what a national court means, is there's one district, right? U.S. tax court is a national court, meaning it's one district, the entire U.S. The district court is 94 different districts. And again, that's going to change in the future. That's going to go up over time. So don't quote me on the 94 districts because that will change in the future. Trust me. As populations change, some states are going to get more districts. So we need more district courts, especially when you need to consider the backlog of cases. The tax court and the U.S. Court of Federal Claims, think of it as like one district. Now, the exception to that is with the tax court, there's also the Golson rule. For the U.S. Court of Claims, all U.S. Federal Court of Claims cases, they appeal up to the U.S. Circuit Court of Appeals for the Federal Circuit. We saw that earlier, and that's very important to understand because no Golson rule is needed because there's not going to be multiple circuits. There's only going to be one. The tax court, you need that Golson rule you need to have some type of application where the 9th Circuit and the 11th Circuit, like California and Florida, could apply a different law, and you need to have some rule, and that's what the Golson rule is. It says that the tax court, while it's a national court, one district idea, and each judge is subject to each other's precedent, they also have to follow the court that they would appeal up to. That's the idea. So it is a national court. It is a national court, and it's located in D.C. It's in D.C. That's where the headquarters are, just like the tax court. Just like the tax court. However, because the Court of Federal Claims judges travel to major cities in these locations, okay, and the judges here in these multiple cities and locations, it's similar to the tax court. So it's a riding court or a riding circuit. It's a riding court, meaning it goes to major cities. So the taxpayer, the attorneys, they do not have to go to D.C. Major cities like New York, Los Angeles, San Francisco, Atlanta, they're going to be hearing cases. So they don't have to, the taxpayer and the attorneys do not have to go to D.C. Question 24. Please provide the citation for the following case information. So we've got one of our favorites, citation question. Let's go ahead and read the facts. The taxpayer's name is Harriet A. Duda. She paid the tax deficiency and brought her case before the U.S. Court of Federal Claims. One judge heard the case. The opinion starts on page 129 of volume 79 of the official reporter for that kind of case. The court's decision was made in 2007. Please make sure to put both parties in the citation and also make sure to use the formal abbreviations for the government party at issue. Also, make sure to properly capitalize certain words and put all potential words, numbers, apostrophes, spaces, commas, periods, and parentheses in the correct location as this matters. Okay, so we've gone through the drill already. We're going to spend some time on this question because I want to make sure that you've got it down. Again, if you're in my class, extremely important. If you're not in my class, still important in practice because eventually this will make a difference in your career somewhere. So we're dealing with a taxpayer. Name is Harriet A. Duda. She paid the tax deficiency, so we know she paid it, and she's suing for a refund in the U.S. Court of Federal Claims. U.S. Court of Federal Claims. One judge heard that case, so we know it's not en banc. The opinion starts on page 129. So let's Write that down. Volume 79 of the official reporter for that kind of case. So it's the U.S. Court of Federal Claims, and because it's heard in 2007, we know that the reporter is the FED, so capital FED period space CL, capital C. Let me do that again to make that a little bit clearer. Capital C L, lowercase l, period, and that is that is the reporter, the federal claims reporter, the official reporter. Now, there is a different reporter prior to, I think, 1992 or 1993. I'm not going to test you if you're in my class. I'm going to test you on this one. So you need to know this citation, this specific report. This is the official reporter. This is the official reporter for the Federal Court of Claims. So you need to know this one. All right. So federal claims. Now let's continue on. The court's decision was made in 2007. Right. That matters. Very, very important. Please make sure to put both parties. So we're going to have the plaintiff and defendant in that order, and make sure to capitalize, do the commas, blah, blah, blah. You get the drill. So remember, the taxpayer is suing here for refund in U.S. Court of Federal Claims. So again, just like the U.S. District Court, it's the plaintiff versus defendant. So the plaintiff here is the last name of the taxpayer. So that's DUDA, D-U-D-A, capitalize the first letter, space, lowercase v for versus, period, space, U, period, S, period. So again, when you're looking at the three trial courts, when you're looking at a tax court, the district court, and the U.S. Court of Federal Claims, U.S. Court of Claims, there is a difference in the parties, right? U.S. Court of Federal Claims or U.S. Court of Claims and the U.S. District Court, the U.S. is a defendant, always. In tax court, commissioner is the defendant, or I should say the respondent, the second party listed. So it's U period, S period. Then we put a comma. Now we do another space. We're going to go to the volume, which is 79. And now we do another space, and then we use this official reporter. So it's going to be capital F, E, D, period, space, capital C, lowercase l, period, space. And then we do the page, which is on page 129. Space, and then we finalize it with the date of the decision. So the decision was made in 2007. So space, 2007, and we are done. So let's just go over and highlight these things. DUDA is the last name of the taxpayer. Space, versus, space, U.S. is, of course, the U.S. government. Again, the abbreviation is asked for, so we did that. Space, 79, space, this is a 7. Make it a little bit clearer. Sorry. Space 79, or space 79, space, federal, FED, period, space, CL, period, space, 129, space, 2007. That's what's going on there. Let's put our spaces. Space here, space here, space here, space here, space here, here, here. And that is the citation. Let's go on. Let's continue to the next question. So question 25. Must the taxpayer pay the disputed tax deficiency to the government before his or her case will be heard in district court, in the U.S. Court of Federal Claims, and in the U.S. Tax Court? So questions 25, 26, and 27 deal with comparisons of the three courts. Now, in the introduction to judicial tax sources, I talked about, or judicial source of tax law, I should say, sorry. There was a slide that compared and contrasted. It gave some advantages and disadvantages, or maybe not, maybe just the differences in each. So that's what these questions are really focusing on, and I'm highlighting on some of those elements. Again, others are discussed in that intro video. So this is just asking, must the taxpayer pay the disputed tax deficiency to be heard in district court? Let's just write out U.S. Tax Court. Let's write out the three trial courts. U.S. Tax Court, U.S. District Court, and finally, the U.S. Court of Claims. And the question here is asking about, must you pay the tax deficiency? So must you pay to play? The lingo in taxes, pay to play. Now remember, two of those courts on the list, we got three. Two of those courts you have to pay to play. I want you to pause the video and think about it, and then you can start it and I'll give you the answer. So the answer is two of these courts you have to pay to play. Those are the district court, so you have to pay, and the U.S. Court of Claims you have to pay, and you're suing for a refund. The U.S. tax court, no pay, you don't pay. You do not pay the tax. So you do not pay the tax. But U.S. District Court and U.S. Court of Claims, you do, and you sue for a refund. Let's move on to question 26. Which of the trial courts is the most appropriate for a taxpayer who wishes to limit the judicial review of the relevant year's tax return to the specific issues involved in the case? This is an excellent question. So, and this focuses on one of the disadvantages of the U.S. tax court. So the U.S. tax court, and this is something that I mentioned in the introduction to judicial sources of tax law, but I didn't really harp on too much. One of the disadvantages of the U.S. tax court is if you bring your claim before the U.S. tax court can consider any issue on their tax returns at issue. So not just the issue before the court, but any issue on the tax returns at issue, any tax years that are at issue. The other courts, the district court and the Court of Claims, U.S. Court of Claims, let me put a line here to separate these, only can hear the issue at hand. Only the issue at hand before the court. They cannot consider other issues. So that is one thing to consider, is that if a taxpayer knows that maybe they might have taken an aggressive position or did something else that's not disputed by the IRS, you might want to consider the district court or court of claims. That's a huge thing. And as I mentioned in the introduction to judicial source of tax law video, it's really situational. There's different situations when one court might be more advantageous to the others. I've concluded that in general, the U.S. tax court's the best because that no pay to play by the U.S. tax court, that's a big deal versus paying to play. And you might not, you might be paying and then that's several years down the line. So that's something to consider, is that the U.S. tax court is a disadvantage because other issues can be brought up. Question 27. Which of the trial courts would best serve a taxpayer litigating an issue of a technical tax nature? Why? So of all three courts, the U.S. tax court is by far the most technical. The U.S. tax court is the most technical. The judges are. Because these judges have practiced tax law for decades, most of them decades, and they are very familiar with almost all issues in tax law. If they're not, they can easily understand issues in the tax law. They can learn about them. Versus the district court and the Court of Claims, the U.S. Court of Claims, are generalists. They don't just deal with tax law, they're generalists. They deal with other issues, especially the district court, where you might hear criminal issues, bankruptcy issues. They don't deal just with tax, and tax is very rare for them actually, versus U.S. tax court, most technical, all they hear is tax. And they have tax backgrounds. So if you're dealing with something that's very technical, like partnership tax or corporate tax, then the U.S. tax court makes the most sense because you want a judge actually understand the issues at hand, especially if you have a strong argument or you have an argument that makes some sense to a tax practitioner. So all they hear is tax versus, again, the other two trial courts, the district court and the Court of Claims, that's not the case. They are generalists. They hear other things. They hear other things as well. Let's move on to question 28. So now we're moving on to the Circuit Court of Appeals, the U.S. Courts of Appeals. So are the U.S. Courts of Appeals, Circuit Court of Appeals, are they national courts? What types of cases do they hear? They are not national courts. Again, a national court would be something where there's one specific district, one specific circuit. There's multiple circuits in the U.S. Circuit Court of Appeals. So it's not a national court. There's a lot of different circuits. I'm going to go through them. So it's not a national court. An example of a national court is the tax court. The Supreme Court is a national court as well because it covers the entire U.S. The U.S. Court of Claims is a national court because it covers the entire U.S., just one country. The U.S. Circuit Court of Appeals, it's called the Circuit Court of Appeals for a reason. So Circuit Court of Appeals, there's circuits. There are circuits. Specifically, at the time of this video, there are 13 different circuits. There are 12 geographic circuits, and we're going to be learning about them in the next few questions. And there's one circuit for the federal circuit, and the only court that appeals there is the U.S. Court of Claims. So one circuit for the federal circuit, and that is the U.S. Court of Claims appeals up to the circuit for the federal circuit. So there's 12 geographic circuits. There's 11 numbered at the time of this video. There's 11 numbered circuits, and D.C. is a geographic circuit. So if you reside in the area of the District of Columbia in Washington, D.C., it's the D.C. circuit, and that is separate from the federal circuit. Sometimes students, when they first learn this, and tax professionals, when they first learn this, they confuse the D.C. circuit and the federal circuit. The D.C. circuit is not the same as the federal circuit. The federal circuit is simply the court of appeals that the U.S. Court of Claims, so here the U.S. Court of Claims appeals to. The D.C. circuit would be if you reside in D.C. and you're a taxpayer, or your business in D.C., those types of issues. The other question, what types of cases do they hear? So the Court of Appeals, the Circuit Court of Appeals, they consider issues in both tax and non-tax cases. The Court of Appeals for the federal district hears, again, only Court of Claims. So that's something very important to understand. The other courts, they consider just from the tax courts, from district courts, from bankruptcy courts, from all different types of U.S. courts. They hear all these different cases. So the idea is that they're generalists. They are generalists. They hear not just tax, they hear all different types of issues. I will tell you that tax, while there are tax cases in each circuit, they're not the most common. There are many other issues. So again, it's like the district courts. Tax is not the most common thing that these Circuit Court of Appeals, they listen to and they hear. Question 29 and 30 ask about the different U.S. Circuit Court of Appeals that apply to specific taxpayers who live or work in each of the following areas. So we're going to go through each of these in question 29 and 30. So taxpayers who live and work in the following areas. And if you're in my class, it's very important that you know the circuits. I provided a map in my video. So make sure you look at that map, understand that. I could ask you I could give you a state or location or other information, and you need to know what circuit it is. So let's just go through these. So, and what I recommend doing is, if you don't know them already, stopping the video, getting that map out, and pulling up that presentation materials, looking at that map, and going through these questions with me. Let's go through the first one. So question 29, let's go through those, and then we'll go through question 30, and we'll go in order. So question 29, Texas. So a taxpayer who lives or works in Texas, what circuit would they appeal to? That would be the Fifth Circuit. So I'm just going to put the number 5, the Fifth Circuit. Okay, next. Next is New York. That's going to be the Second Circuit, so 2. California. California is in the Ninth Circuit, so that's going to be 9. Colorado. Colorado is going to be in the 10th Circuit, so that's number 10. Washington, D.C. Washington, D.C. is in the D.C. Circuit. So remember, there are 12 geographic circuits, 11 numbered circuits, and there's the D.C. Circuit. The D.C. Circuit, okay? Keep that in mind. Now, by the way, if you're watching this in the future, there might be some changes. There may be some changes to states. Things may have changed. There might be a new circuit that comes out or whatnot. So keep up on that. If I put something down, just keep that in mind. This is at the time of the video. And if you're taking my class, don't worry. I will make sure that I ask you the correct ones, and you need to learn the correct at the time. You can easily just go online and search for the U.S. Circuit Court of Appeals maps, and you can find it. You can just do that to find the most up-to-date. The last one is a case that is appealed from the U.S. Court of Federal Claims. That's going to be the Federal Circuit. Again, the D.C. Circuit and the Federal Circuit are not the same thing. The D.C. is a geographic one where people located in Washington, D.C., and companies located in Washington, D.C., they appeal to that. The Federal Circuit is where the U.S. Court of Federal Claims appeals up to that. That's the only one that appeals up to the Federal Circuit. So just keep that in mind. Let's go to question 30. So same thing, got some states. Let's go ahead and determine which specific area they're in. So Pennsylvania is in the Third Circuit, so I'll put a 3 there. Indiana Indiana is in the seventh. South Carolina is in the fourth. Massachusetts is in the first. Florida is in the 11th. Kentucky is in the sixth. And Minnesota is in the eighth. Now, again, my students out there are like, wow, I have to learn every single state and what they're in. I will tell you that the questions that I ask on the exam are ones that are a lot clearer. I try to focus on the biggest states: California, Texas, New York, Florida, Illinois, and also big cities like Boston, Atlanta. I try to focus on those. I try not to be like ask obscure states, like especially when you start looking at places like Indiana versus Illinois versus Kentucky versus it makes Ohio. Those are all, it makes a big difference. Michigan up there in that Midwest, it makes a huge difference because it's not really as clear. I try to make it a lot easier for you, especially, there might be some states that you might be more familiar with because you reside in them. So make sure you know those at least, because especially that's what you're going to be practicing in. So just keep that in mind. I definitely will not ask you about the territories. I don't ask about territories, but I try to focus on the big states, which a lot of them are on here, right? Texas, New York, California, those are the big ones. Florida's big. There's a few other big ones on here that aren't on here that I might ask you about. So just get a general idea. A general idea about where those are located. Again, I don't really try to ask too tricky ones, the real tricky ones. Question 31. Each court of appeals has approximately 20 judges. I would say that, by the way, you're going to see that if you look online, some circuits, they have a lot less than 20 and some have much more than 20. So I think that's kind of like the median or average at the time of the video, which again, it's likely to change in the future. So even though it says approximately 20 judges, I really mean like an average of 20 judges. How many of these judges typically hear a case? There is a panel. As I talk about in the introduction to judicial sources of tax law, the Circuit Court of Appeals, the appeals process is much different than trial court. It's not the same thing like you see on TV. It's more of a presentation, and it's a 3-court panel. A 3-judge panel is the typical. So usually 3 judges will hear a case. There is en banc. You can have en banc potentially with all judges. Potentially all judges. That is possible. Okay? En banc is possible, but usually it's a 3-judge panel. So keep that in mind, 3-judge panel. Let's go to question 32. Please provide the citation for the following case information. So we've got one of our favorite. We've got our citation questions. Let's go ahead, spend some time, go through this, really understand it. Again, if you're in my class, very important that you know how to do this. We'll be tested on it. The taxpayer's name is John W. Roberts. He paid the tax deficiency and brought his case before the U.S. District Court for the Northern District of Georgia. John lost the case at the trial court level and is appealing the case to the U.S. Circuit Court of Appeals. A normal 3-judge panel heard the case. The opinion starts on page 698 of volume 858 of the second edition of the official reporter for that kind of case. The oral arguments were heard in 1987. The court's decision was issued in 1988. Please make sure to put both parties in the citation and also make sure to use the formal abbreviations for the government party at issue. Also make sure to properly capitalize certain words and put all potential words, numbers, apostrophes, spaces, commas, periods, and parentheses in correct location as this matters. Do not use the form CA and then the number or DC or federal in the citation, but use the other official form in the citation. I'll explain that later on, and I don't want you, if you're taking my class, to use that on the exam. You might do that on your memos. That's fine because you can use that. It's a alternative, but on the exam, I want you to use the official portion of citation, which I'll explain when we go through this. Okay. So let's go through each of these elements. We know the taxpayer's name is John W. Roberts. That's obviously important. He paid the tax deficiency and brought his case before the U.S. District Court for the Northern District of Georgia. John lost the case at trial court level and is appealing the case to the U.S. Circuit Court of Appeals. So we are dealing with the U.S. Circuit Court of Appeals case. And by the way I write questions, I'm going to give you the lower case and the lower cases, but it's important that you know that the highest level case I give you, that's the one I want you to cite. So it tells you it's the opinion. The opinion starts by this 3-judge panel on page 698. We need to know that, of volume 858 of the second edition of the official reporter for that kind of case. So it's a U.S. Court of Appeals, and it's the second edition of the official reporter. So the reporter is the federal reporter, which is F dot, just like that. If it's a second edition, it's F dot 2D, no space. No spaces there. Let me make that a little bit clearer. There are no spaces, so it's F dot 2D. If it's a third edition, F dot 3D. No space. No space in that citation there, in that part of that citation. And there'll be more in the future. These are not finite, but those are the ones at the time of this video that we have up to the third edition. F dot 3D. Okay, so that is the citation. It's saying the second edition, so we are using the second edition. That's this one right here. It's a Circuit Court of Appeals for U.S. Circuit, so it's that. And again, I know some of you out there might be sticklers when it comes to tax research. There are originally older reporters for U.S. Circuit Court of Appeals, but I'm using just these. I'm using because the cases that I'm going to give on my exams, and also the ones, when you think about law, the ones that are most important, they are from the Federal Reporter series. Okay, so I shouldn't say they're not the only ones that are important, but for tax, think about, more recent tax cases. They're the Federal Reporter series. All right. We're also told that the decision was issued in 1988, oral arguments heard in 1987. We care about when the decision was issued by the court, so that's the important date, the 1988. And it says make sure to put both parties. So we're going to go ahead and start our citation. Now, here's something that's a little bit trickier. When you're dealing with an appeals case, you have to know which party is appealing. That's going to be the appellant, right? You're going to have the appellant versus the appellee, like that. So the appellant goes first versus the appellee. You need to know which one goes first. If you do them out of order, you will get the citation wrong, because the way that you write the citation tells who is appealing what, who lost the below case. That's the idea. So let's see if we're told who lost. We're told that John lost the case at the trial court level and is appealing. So John is going to be the first party. So it's going to be the last name of the taxpayer first. So the appellant here is John Roberts. So that's going to be Roberts. So Roberts, let's write that S again. Roberts, space, little v, period, so versus. So space, little v, period, space. Okay, now we need to know, is it the commissioner or is it U period S? Which one is it? Well, we look at the original trial court. If it's a U.S. District Court or the U.S. Court of Claims, it's going to be U.S. So it's U.S. District Court, so it is U.S. So U space, U period, S period, comma. So U period, S period, comma. Let me rewrite that comma. So U period, S period, comma. Now we get into the actual reporter. So we look for our volume. Our volume is, so we do space. The volume is 858. Another space. Now we do our second edition of the official reporter. That's this. So space, F period 2D. No spaces there. F period 2D, and then we do another space after, and it's the page it starts, which is on page, so space, page 698. Okay. Now we do another space, and then we do our parentheses, the end of the citation. Okay. So in the parentheses, by the way, we're told that it's in the U.S. District Court for the Northern District of Georgia, but that doesn't matter. We don't need that for the citation for the Court of Appeals. We would need that for the citation for the trial court, but I'm asking you for the Court of Appeals here. Again, if I give you information, I want you to give me the highest level case, the case at issue that is with respect to the volume that the judges are issuing the case. So we have our parentheses. Now we're going to do our circuit. Now again, do not do CA dash and then the number that the circuit's located, or DC or federal. Do not do that, because I'm telling you not to do that. And the reason why it's important for my students is because the way that I grade it. Again, you can do that in practice. You can do that in your memo. But for the exam, I want you to use the official citation. So you need to follow the way I'm doing it right here for your exam. So it's going to be, we have to find out what circuit it is. Well, it's in Georgia. That's why I gave you the Georgia. He brought the case before the U.S. District Court for the Northern District of Georgia. If it was a tax court case, I'd have to tell you where the taxpayer resides. Or what, I'm sorry. Yeah, I have to tell you where they reside. So Georgia appeals up to which circuit? It's going to be the 11th Circuit. So you can look at your map. Now, the way we write this is we're going to write 11th. We're going to write 11th. Just like that. So that's 11th space CIR, so capital C, lowercase I, lowercase r. Then we do another space and we put the year the case is decided. So the year the case was decided, not 1987, 1988. So we're going to put 1988, close the parentheses. Let me redo that. Close the parentheses, no space there, and we're done. So let me explain this. Roberts is the appellant. The appellee is the U.S. The reason we knew that is because we're told John lost the case and appealed to the U.S. U.S. Circuit Court of Appeals. So Roberts space lowercase v dot space U.S. The reason we know it's U.S. is because it's not a tax court case. It's U.S. District Court or U.S. Court of Claims, comma, space. It's in volume 858 of the second edition of the official reporter, which is F.2D, space 698. Starts on page 698, space 11th. So 11th space CIR dot or period dot 1988. And that is the citation. Let me go ahead now and put in our spaces and we will be done. So it's Roberts space V dot space, we have a space after the comma, space after 858, space after F period 2D, space after 698. Then we've got 11th space, circuit space, boom. Just like that, that is our citation. If you can follow that, you're good. Let me just write out what the other circuits would look like, right? You have first, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th. What about DC and Fed? DC and Fed would be D period, C period, space, circuit, same with that. And then Fed would be F, capital F, E, D, period, just like that. So the idea is that you want to keep it to no more than really 3 characters. That's what they're making you do. That's the official abbreviation. So those are the abbreviations like that. I know that 10th and 11th obviously have more than 3 characters, same as DC. And if you count the dot, it's a character, right? But they're trying to keep it limited in terms of what it is. But that is how you'd write that out. Okay. So make sure, you go over and practice that. Remember, the appellant is Roberts here. The appellee is the U.S. government. U.S., again, practice that one. Very, very important. You'd have to understand, given that type of information, how to create that. Question 33. Can a taxpayer have a jury trial before a court of appeals? So the only court, when it comes to tax cases, where a jury trial is possible is the federal district court. No tax court, no U.S. Court of Claims, no appeals courts. So we're talking about a court of appeals. No jury trial can take place before a court of appeals. Appellate decisions are heard by judges because they're matters of the law. So the U.S. Circuit Court of Appeals, as well as the Supreme Court, the 2 appellate courts, when it comes to tax cases, they're questions of law and there's no jury. So no jury. Again, the only case when you're dealing with tax where a jury trial is possible is a federal district court. Question 34. What is the highest court in the United States? What is its jurisdiction? Where does it hear cases? So the highest court in the United States, highest court in the land, Supreme Court of the United States, also abbreviated as SCOTUS. So Supreme Court of the United States is the abbreviation. Its judicial power extends, we're talking about jurisdiction. So in terms of jurisdiction, we go to the Constitution. Its jurisdictional power extends to all cases of law and equity arising under this Constitution, the laws of the United States, and treaties. So the idea is that under the Constitution, the laws of the United States, so the laws of the U.S., and even treaties between countries, between the U.S. and other countries. Now, important to note is that when you look at the state court system, I know we're talking about federal tax law, the ultimate court when it comes to state courts is actually the Supreme Court of the United States. You would start when you're looking at the state court level, you have the trial courts, the appellate, and then you have the state Supreme Court, which, by the way, in the state of New York is not called the state Supreme Court. It's just called the New York Court of Appeals. And then beyond that, it would go to the U.S. Supreme Court. So the U.S. Supreme Court is by far the highest level court in all of the United States. And it's, again, under the Constitution, it deals with cases, to all cases of law and equity arising under the Constitution, the laws of the United States, and treaties. Where does it hear cases? All cases are heard in Washington, D.C. It does not ride around. All cases are heard only in Washington, D.C. Question 35. How does one petition the Supreme Court to hear one's tax case? So a U.S. citizen does not have an automatic right to have his or her case heard by the Supreme Court. It's not like when you're talking about tax cases, the U.S. Circuit Court of Appeals, where a taxpayer or the IRS has the right to appeal to the U.S. Circuit Court of Appeals, and the U.S. Circuit Court of Appeals has to at least consider the case. They might not hear oral arguments, but they have to at least consider, affirm, or take on oral arguments. The Supreme Court, that is not the case. There is no right by any party that the Supreme Court has to hear your case. The court's permission to present the case is petitioned by what's called a writ of certiorari. So CETIORARI, or we abbreviate that CERT, a writ of certiorari. Under this procedure, if the court decides to hear the case, the certiorari is granted. So you'll see it says cert granted. Now, at the time of this video, there are 9 Supreme Court justices, 9 justices on the Supreme Court, 8 normal justices and 1 chief justice. Now, the normal justices are broken into senior justice, associate justice, depending on how long they've been there. But there's 9 justices total. So there's 9 justices. Again, 8 and 1 chief justice. At least 4 justices have to grant cert for the case to be heard. Or I should say at least 4 have to vote. At least 4 needed for cert to be granted. That's the best way to put it. You would need at least 4 for cert to be granted. The idea is that not every case can be taken by the Supreme Court. We have to take the most important ones. That's the idea. And by the way, if the Supreme Court is granting cert, does not grant cert, it doesn't mean that it agrees with the lower case. It's just saying that we're not going to hear it, and therefore the final decision is by the U.S. Circuit Court of Appeals. Question 36. How many justices are appointed to the Supreme Court? How many hear each case? All right, we just talked about this. There are 9 justices. Again, there's 8 regular justices and 1 chief justice. How many hear each case? All 9. All 9 justices. Now, occasionally you might see some cases, like in the introduction to the judicial sources of tax law. We saw the Glenshaw Glass Supreme Court case. One of the justices, Justice Harlan, didn't hear the case, wasn't there. Sometimes they recuse themselves from the case. They don't hear it, or maybe they're ill. But the idea is that generally all 9 justices hear the case. Question 37. Why does the Supreme Court hear so few tax cases? In most cases, those petitions that are granted in the tax area are for cases that involve either a conflict among the circuits. So if there's conflict among the circuits in terms of how to apply the tax law, so conflict among the circuits, and the other one is a tax issue of major importance, or a tax issue of major importance. So that's why in the Supreme Court, not many cases out there dealing with tax. That's the technical answer, I would say, is because The Supreme Court, when they deal with tax cases, they deal with cases that involve a conflict among multiple circuits where it's being applied differently. And not every issue that there is a conflict, the Supreme Court will hear either. Sometimes they've said, okay, we know there's a conflict, but we're not going to hear it. Or it's a tax issue of major importance where it affects the U.S. population in a way that needs to be heard. Another reason why the Supreme Court doesn't hear tax cases, when you look at most of the Supreme Court tax cases, most of them came out in the early history of the U.S. tax when there was a lot more ambiguity. As we go in time, there's less Supreme Court cases because those things get fleshed out. I mean, of course, we have new tax laws, so there's new interpretation issues, and that's understandable. But as we go in time, a lot of those issues have been hashed out already, and they haven't been overturned by the court, so they're simply the precedent that's being used. Another issue is most of the issues that are heard by the Supreme Court, they focus on the Constitution. Not too many constitutional aspects of tax that are at issue. It's more about application of certain terms and phrases in the law, and that's usually why the Supreme Court doesn't hear it. A lot of issues before the Supreme Court deal with due process and items in the Constitution and the amendments to the Constitution, those types of things. And there's just not a lot of that in tax. Question 38. Differentiate between the Supreme Court's overturning of a lower court's decision and its denial of a writ of cert. So I talked about this earlier. When denying cert, so when the Supreme Court denies cert, certiorari, we talked about that earlier, the Supreme Court is not, I repeat, they're not upholding the lower court decision. They're not affirming it. They're not upholding it. Rather, the Supreme Court did not find the case to be interesting or important enough to consider during its limited sessions. The lower court's decision does stand, but it cannot be inferred that this decision is necessarily correct or should be followed in the future by other taxpayers with similar situations. So just because the Supreme Court denies cert doesn't mean that it's like it establishes the precedent. Versus if the Supreme Court overrules a lower court's decision, that then becomes precedent. That's the main thing. Is denying cert is not upholding the lower court, so we can't rely on that denial of cert as precedent. However, if the Supreme Court overturns, that can be used as precedent for similar issues. That can be used for precedent. I would say that's the biggest element. The rest of it really comes down to semantics, but that's really what it is. Question 39. Please provide the citation for the following case information. And here's one of our favorites, and here's the good news, because some of you might be out there like, oh, I can't believe we got another one of these questions. Here's the good news. This is the last one. Woo! Yes, the last one. But again, remember, if you're taking my class, if you're a tax professional, very important you understand how to cite cases. Very, very important. And again, I focus on the official reporters. Let's go ahead and let's read the facts. Let's get this one done. Yeah! All right. The taxpayer's name is Frances L. Dahm. She paid the tax deficiency and brought her case before the U.S. District Court. Frances lost the case at the trial court level and appealed the case to the U.S. Circuit Court of Appeals. The U.S. Circuit Court of Appeals reversed the trial court's decision in favor of Frances. The government appealed to the U.S. Supreme Court. The U.S. Supreme Court granted cert and heard oral arguments in 1989. The decision was made in 1990. The opinion starts on page 596 of volume 494 of the official reporter for that kind of case. Please make sure to put both parties in the citation and also make sure to use the formal abbreviations for the government party at issue. Also make sure to properly capitalize certain words and put all potential words, numbers, apostrophes, spaces, commas, periods, and parentheses in the correct location as this matters. Woo! A lot of information, right? So remember, I'm asking you for the highest level. I give you the trial court, I give you the U.S. Circuit Court of Appeals, but it's going to the U.S. Supreme Court, and that's what's at issue. Now, remember, let's go through these things. Taxpayer's name is Frances L. Dahm, right? That's going to be important. The last name is always important, so that Dahm is important. She paid the tax deficiency, right? So we know she's paying it and she's suing for a refund, so it's either going to be U.S. District Court or U.S. Court of Claims. It's the U.S. District Court. So we know it's going to be the U.S. is the party, not commissioner, not COMM''R. Frances lost the trial level and appealed to the U.S. Circuit Court of Appeals. The U.S. Circuit Court of Appeals reversed the trial court's decision in favor of Francis. What do we care about? Do we care about if we're citing the U.S. Supreme Court DALM case, D-A-L-M case for this taxpayer? Do we care about what happened for the citation? Do we care about what happened at the trial court, or do we care about what happened at the U.S. Circuit Court of Appeals? Well, let me explain another way. Remember, for appeals decisions, whether it's the U.S. Circuit Court of Appeals or the Supreme Court, we have the appellant versus the appellee. The appellant versus the appellee, and we go in that order. Now, Francis lost the case at the trial court level, so at the U.S. Circuit Court of Appeals, she would have been the appellant. However, at the U.S. Circuit Court of Appeals, it was reversed, and the government is who is appealing. So that is the appellant. So again, because this is a U.S. District Court, we're not going to do commissioner. We're going to do U.S. space, verse, and the appellee here is going to be the last name of the taxpayer, D-A-L-M. Let's go ahead and write that and start our citation, right? So we're making good progress. So we've got U.S. space, lowercase v period, space, DOM, comma, just like that, right? As you're seeing from these different citation questions, there's a format, there's similarities, and that is true. There's some differences as well, like the types of reporters, and at the end, how you do the parentheses, but for the most part, the format is very similar. You have the parties' names, you've got the reporter, and you've got the year, maybe some geographic location. All right, we got that. So US v. DOM, we've got that. Now we have to talk about the reporter. So we're dealing with the Supreme Court, and it says it's the official reporter of the Supreme Court of that kind of case. The official reporter for the Supreme Court is the U.S. reporter. U.S. reporter. That is the official reporter. The volume is volume 494. So we're going to do US v. DOM as we have it here, comma, space 494 space U.S. space. Then we do the page 596, the page it starts on. So U.S. space, page 596, that's where it starts, space, and then in parentheses, what are we going to put? We're just going to put the year. The year that it was decided, not the year it was heard. A lot of times the Supreme Court, it takes time for the opinion to come out, even though the oral arguments were usually in the previous year. So this is this is decided, not heard, decided in 1990. We don't put 1989, put 1990. So 1990, close parentheses, and that is it. So again, let's go through the citation. We start with the parties. We start the appellant. The appellant here is the party that lost to the lower court, which we're told the government lost. And again, it's not going to be commissioner because it started at the U.S. District Court. So we put U.S. space, little v period, space for verses. DOM is the name of the taxpayer, comma, space, 494, space, 4 U.S., period, space, 596, which is the page, space, 1990, that's the year that it was decided. Let's put our spaces in, and boom, we have finished our last written citation. We do have a few questions about citations and how to identify them later on, but this is our last one. And again, if you're taking my class, all the citations we've gone over here, I can test you on those. And again, it'll be very similar in terms of how I ask. So space here, space here, space here, space here, space here, space here, boom, just like that. That's a citation. We got it down. So practice that. And again, go online for all these citations we've done for the U.S. Tax Court, regular opinion, TC memo, for the U.S. District Court, for the U.S. Court of Claims, for the U.S. Court of Appeals, for the U.S. Supreme Court. You can go online. You can find you can find other opinions and find them. Go online and find these and practice. The idea is that I'm going to ask you the official reporters, so it's the ones I did in these problems. And I actually showed you on the district court, on the U.S. Circuit Court, that, if it changes to a second edition, third edition, fourth edition, whatever it is, I explained to you how that would change. I explained to you when we went over this problem, so make sure you review that. Okay, let's go on. Let's go to question 40. Is it possible for a taxpayer to have a jury trial before any of the trial courts? before a court of appeals, before the U.S. Supreme Court. So this one's pretty easy because we've gone over it so many times. We talked about it in the introduction to judicial sources. I talked about it here. Very important question. The only court of any of the possible tax courts, or I should say the only of the cases where you bring a tax case, would be the U.S. District Court. And it's possible, but not 100% guaranteed. The U.S. District Court is possible. All others, you're never going to have a jury. So, all others. So we're talking about the U.S. Tax Court, the U.S. Court of Claims, the appellate courts, which is the U.S. Third Court of Appeals, and the U.S. Supreme Court. All others, no jury trial available, ever. So U.S. District Court is possible. This is one possible advantage of why you might want to go U.S. District Court. Let's say the taxpayer has some kind of sympathetic tax issue, like dealing with tax penalties, and IRS is really bringing the fire and trying to get this taxpayer, and maybe this taxpayer's down on his or her luck and just had a few really bad years. They messed something up, or maybe it's like an innocent spouse issue. That's a lot of times what comes up before the tax court, and a jury might provide a more sympathetic approach than maybe certain judges would. That's the idea. Although judges try to be sympathetic, not always, but they try. So if it's a sympathetic issue, that might be something where the attorney says, "Hey, we can really play on the jury on this." That's an example of where you might want to use that. Question 41. Discuss the precedential value of a Court of Appeals decision. Which Court of Appeals decisions are the most important to a specific taxpayer? So we've kind of already gone through this. We're talking about the U.S. Third Court of Appeals. Of course, if it was Supreme Court of the United States, which technically is an appellate, it is an appellate court. It is an appellate court. All courts below are subject to, and the Supreme Court are subject to Supreme Court cases, as long as they haven't been overruled or distinguished, or the courts don't distinguish it in some way. But we're talking about the U.S. Circuit Court of Appeals. So remember, for the U.S. District Court and the tax court, so the tax court and district court, it's all about the geographic area that the taxpayer resides. For the Court of Claims, for the U.S. Court of Claims, it's always going to be the federal circuit, always. So the question is, discuss the precedential value of Court of Appeals decision. Which Court of Appeals decisions are most important to a specific taxpayer? If you're looking at the tax court or district court, then you focus on the geographic area the taxpayer resides to find the U.S. Circuit Court of Appeals that applies, right? Again, at the time of this video, there's 11 numbered geographic circuits. There's also D.C. circuit. And then if it starts in the U.S. Court of Claims, then it's the federal. If you're talking about Supreme Court of the United States, that applies to all courts, and even the Supreme Court is bound by other Supreme Court law. That's the idea. Now, a question about what if you're in another circuit and there's nothing that applies to you? Well, then that court is not bound by any specific circuit. If there's nothing that applies within that circuit, they are bound by the Supreme Court. That other than that, they can look to other circuits as persuasive, but there's nothing that binds them. That's the idea. Okay, let's go to question 42. These next few questions, while you're not writing out citations, you need also, in addition to understanding how to write out the citations like we saw before, and if you're in my class, I'm going to ask you to write out citations. You might be asked to interpret a citation as well, so you need to know how to do this. So question 42, in the fictitious citations, that means that this citation is not a real citation. Smith versus Commissioner, and that's the abbreviation for Commissioner, 104 space TC space 123 space 2009. So that's written properly. That's a 100% accurate citation if this was a real case, right? Obviously, if you go to 104 TC 123, you're not going to find the Smith case in 2009. What does each element of a citation mean? Okay, let's break this down by Keller coding. So first, Smith, which I'm going to underline in black. I'm going to use black for that one. That is going to be the taxpayer's name, and it always goes first. Always goes first. Okay, always goes first when you're dealing with a tax court case. Smith. Next, we've got the V, which is the verses, but we'll skip that. You understand versus, right? That's the format for a two-party citation, which I do two-party citations. Commissioner, so that of course is the IRS commissioner, and if it's a tax court case, you're going to have commissioner. If it's a U.S. District Court or the U.S. Court of Claims, it's going to be U period S period. Okay, it's going to be U period S period. And the Smith, one thing to note, the Smith, this is called the petitioner. It's not called the plaintiff. It's called the petitioner. The commissioner part, that's known as the respondent. So in a tax court case, the petitioner is always the taxpayer. The respondent is always the IRS. Now, in appeals, we have the appellant and the appellee. Appellant is the party that's appealing. Appellee is the party on the other side that's responding. You can also use petitioner and respondent there as well. Those are synonyms. Petitioner means appellant. Respondent means appellee. But in the tax court, we can't say the taxpayer is the appellant because it's not an appeals decision. When it comes to the U.S. District Court and the U.S. Court of Claims, those are plaintiff versus defendant. Those are plaintiff versus defendant. All right, let's go ahead and let's continue on in our citation. So remember, I'm big when it comes to the following the spacing, the commas, all that stuff. If you're asked to write a citation, it's extremely important you get 100% correct. 100% correct or it's not correct. You have to make sure you do that. And again, you can follow the examples I've done. If you're taking my class, the questions I'm going to ask you are very similar. What's the 104 mean? 104, it's in the 104th volume of, we're going to go next. Let's go to green, the TC. TC, that is the official tax court reporter. So again, if you're taking my classes, I focus on the official citations, and that is the official reporter. Let's go now to yellow. That's going to be the page number that the opinion starts in that 104th volume. The opinion starts on that page. Now, one thing I didn't note is that when you see citations and memos, and I show this in my How to Write a Memo video and other memo videos, when you see a comma after that first page, if you see a comma after, like if you had 104 TC 123, 125, if the memo is citing to a specific part of the memo, a specific idea in the memo, then that's where you'd find it in the opinion, that specific idea. But you always at least start with the page that it starts on, which is here's the 123. If you were to do 123, 125, I would say, okay, the opinion starts on page 123. The area I want you to focus on is on page 125. And then finally, I'll go back to black. The 2009, put that down here, is the date decided. It's always the date decided. Sometimes cases are heard in previous years and then they're decided in later years. We care about the date decided. That's more, you see that more when it deals with appellants, because appeals cases, because it usually takes longer for it to be decided. So let's just review. Smith is the petitioner, also the taxpayer. Commissioner, of course, is the IRS commissioner. That's the respondent. 104 is the 104th volume. TC is the official tax reporter. The page, which is the 123, is the page number that the opinion starts on. Again, if you had a comma with another number after that in a memo, that's the page that the reader wants you to focus on, or multiple pages. And then finally, 2009 is the date decided. Let's go to question 43. Which court would have issued the fictitious case Dell versus U.S., 98 TCM 86 2009 decision? Okay, what does each element in the citation mean? Let's take a look at this. And you're probably going to hate me for this, but this is actually a trick. Dell versus U.S. TCM. So TCM, what do you think that stands for? That is the unofficial tax court memo reporter. TC memo is the official one, but that's the unofficial. So far you're saying, okay, well, how is this a trick? The trick is right here. Dell versus US, TC memo, TCM. What's the problem here? The problem is if it's going to be before the tax court, right? If it's a TC memo, TCM, that means it went before a tax court, and you can't have U.S. It'd be commissioner. So this is actually, I told you it's fictitious, but the problem here is that you can't really explain what this is because this makes no sense. So my answer is this makes no sense. I mean, we have the citation above for a legit TC case. This one is, yes, I'm telling you it's fictitious, I'm making it up, but there's also some limits and bounds. So TCM is the unofficial tax court memo. By the way, it's the one CCH publishes. It's one of the unofficial. It's not the official. The official TC memo would be T period, C period, space, memo, and you put the year and the number of the decision in that year afterwards. That's the official one. This is the unofficial tax court memo citation for CCH. So I'm just going to say that this was meant to be, I wouldn't say a trick, it's just meant to show you, gotcha, that, hey, look at that, you can't have U.S. when it's a TC memo. It have to be Dell versus Commissioner. If it was Dell versus Commissioner, 9-8 TCM 8/6/2009, then you could go through and do the same things. It'd be exactly like number 42. Dell would be the petitioner, taxpayer's name. Commissioner would, of course, be the IRS commissioner, the respondent. 98 would be the year of the tax court memorandum. It'd be the volume of the tax court, unofficial tax court memorandum volume of CCH, not the year, sorry. I'm thinking of the TC memo with, again, the year and whatnot. And then it would have page number where it starts on page 86, and then 2009. 2009 is that's the decision date. So that's a fictitious citation, but even though it's fictitious, it's just so completely blatantly wrong that it's important to note that. Now, the reason why I put this question on here is because if you're taking my class, I might give you a true and false or multiple choice question where I put that as one of the choices, and you should know that's incorrect. That's not possible to be a citation, and you should do the same thing. I don't usually use, I'll tell you if it's fictitious, but in that case, I would say, like, does this citation, could this be a correct citation? You would say false. Or if I'm saying which of these citations is the correct way to cite a case, and assuming they're all correct real citations, and you see a US and a TCM like that, you could obviously eliminate that. So that's the reason why I do this one. Okay, let's go ahead and move on to the last set of questions. Question 44. The citation Simons Eastern v. U.S. 354 Federal Supplement 1003 District Court Georgia 1972 tells the tax researcher that the decision is from what court? All right, so I'm going to tell you what court it is, and there's two ways that you know, and you really have to put them together because you've got here District Court Georgia and you've got Federal Supplement. Now, I will tell you that the Federal Supplement is used not just for tax cases. It's used for district court cases, and it's used for other federal cases as well. There's certain other federal cases as well that are published in there. So it's important to note that these together, the Federal Supplement plus the District Court of Georgia, means that is a U.S. District Court case. That's how we can conclude that. A U.S. District Court case. That's how you would look for that. Let's just go through, just for fun, and let's just summarize what all these elements are. So Simons Eastern is the last name of the taxpayer, the plaintiff, the taxpayer. So we call that plaintiff. I use pi. That's what we do in law school. So pi or P equals pi equals the taxpayer equals plaintiff. U.S., of course, is the D or defendant, right? It's always U.S. The defendant is always the U.S., abbreviated that way in district court cases and U.S. Court of Claims cases. Federal Sup is the reporter. So it's the first edition of the Federal Supplemental Reporter. 354 is the volume. 1003 is the page number that it starts on. And then it was decided in the District Court of Georgia in 1972. So that's really everything. You've got the plaintiff's name, you've got the defendant, you've got the volume, you've got the page number it's on, you've got which specific reporter and what edition, you've got where it is and what the date is. You can find all that from that citation. Let's move on to question 45. By using only a citation, state which court issued each of the following decisions. Also, please provide any other information that can be determined from the citation. Okay, so the first one, Davis versus U.S. 43 Federal Claims 9/2/1999. I'm going to do a different color with each of these because it might get a little messy. I'll try to be as organized as possible. So first thing, it's asking state which court issued. We can determine this one easily by the reporter. This is going to be the U.S. Court of Claims. The U.S. Court of Claims, also known as the U.S. Claims Court. That's what it previously was called. So U.S. Court of Claims. That's how we know that. Let's take a look at these parties. We know that Davis is the taxpayer. We know that the U.S., of course, is the government, the defendant. We know the volume of the federal claims reporter. We know the page number it starts. And we know the year. So we know all those things just from that citation. Okay, let's go to the next one. The next one is Crummy versus U.S. 397, Federal 2nd, 8-2, 9th Circuit, 1968. So I'm going to write on the left side. Okay, so what court is this? It's the 9th Circuit Court of Appeals. I'm just going to put CA. CA for Circuit Court of Appeals. So 9th CA. It's in the 9th Circuit Court of Appeals. Now, the parties, the appellant is Crummy, and that is the taxpayer, which means that Crummy lost the decision below and is appealing. U.S. is the appellee, so they are not the party that's bringing the appeal. That's the U.S. Also, because U.S. is using the title, we know that this either originated, actually we know it originated in one place. It's in the 9th Circuit. We know that the appellee is the U.S. Your two options when it's U.S., there's two options. District Court is where it originated, or the U.S. Court of Claims. Now, those are possibilities if there's U.S., but you're told it's 9th Circuit, and remember that if you're appealing the U.S. Court of Claims, where does it have to go? The Federal Circuit. So this is kind of how you're seeing where I might be asking questions on the exam, or where your professor might be asking questions. It's like through this, what can you tell me through a citation? So that means that it originated in the district court somewhere in the 9th Circuit. We don't know where because the 9th Circuit's quite large. Multiple states, Oregon, Washington, California. We don't know. We can't tell from this citation, but we know that it originated in some district in the 9th Circuit. And Crummy was the taxpayer. Crummy lost the case. U.S. is the appellee here. 397, of course, is the volume. So we got V for volume. Federal 2nd, of course, is Federal 2nd reporter. 8-2 is the page. I'll put page there. And then 1968 was the year it was decided. So those kind of things at the end, as you become more familiar, you can just say, okay, yeah, that's of course volume, report, page it starts on. It's in the 9th Circuit year. But the things we just basically used our reasoning skills, and we determined, hey, it's a district court somewhere in the 9th Circuit. That's where it originated. We can tell that from that citation. See how cool that is? Okay, let's move on, and let's go to a blue. U.S. v. Good, 342. Federal 3rd, 741, 7th Circuit, 2003. I want you to stop the video. I want you to try this one, and then we'll go through it together. Okay, you got it? Let's start with the parties. So we've got U.S. v. Good. So U.S., I'll do it we'll write over here. U.S., that party is the appellant, and that means that the U.S., lost at the trial court, and they're appealing. Good is the taxpayer. Now, we know this case. The question is, what case? We know easily it's the 7th Circuit. It's the Court of Appeals, the 7th. It's the 7th Circuit Court of Appeals, which that area is where you find Illinois and those states. Can we determine where this case originated? Yes, using the same analysis for Crummy, we know, okay, well, the party is U.S. It's either going to be a district court or U.S. Court of Claims. It can't be U.S. Court of Claims because it's not the Federal Circuit. Therefore, the trial court, I'll write out trial court so you don't confuse it with tax court. Trial court for this case was a district court somewhere in the 7th Circuit Court of Appeals, CA Circuit Court of Appeals. So somewhere in there. So U.S. good. 342, of course, is the volume. It's the federal third reporter. 741 is the page. We know it's the 7th Circuit and that the decision was in 2003. Finally, the James case. So let's do that one in green. And I'll actually do that one up here. So we've got James. James comes first. That means that James is the appellant. And it's U.S. with a date. That means that we're talking about the court is the Supreme Court of the United States, SCOTUS. So that means that the James the appellant lost at the U.S. Circuit Court level. U.S., of course, is the appellee here. Now, because, I'll write this over on this side. Again, keeping with the green font. Because U.S. is in the title, we know it originated in the district court or the U.S. Court of Claims. The U.S. Court of Claims. Can you look at this and determine which one it was? No, because we don't have the circuit. We just know that it's up at the Supreme Court. It could be the Federal Circuit. We don't know. So it could be the U.S. Court of Claims. We just know it's one of those, district court or U.S. Court of Claims. We know it's not the tax court. It would say commissioner. Then we got 366, which of course is the volume. 213 is the page. And we know it was decided, the decision was made in 1961. So see how we did that? Go back over that, right? We were able to determine under the Crummy case that, look, it came somewhere in the 9th Circuit, a district in the 9th Circuit, just by looking at the citation. See how we did that? With the U.S. v. Good case, we were able to determine that it came from somewhere in the 7th, a district court and somewhere in the 7th Circuit. It wasn't the tax court, wasn't the Court of Claims. We can do that. With the Supreme Court, you can't do that, but you can determine which party lost at the lower level. The taxpayer did. So that's also helpful. Okay, let's move on. Let's move to the next question, question 46. So question 46, what is a case head note? How might it be useful to the tax researcher? So in my video that I have on the introduction to judicial sources in tax law, I went over the Glenshaw Glass cases, and there were some head notes and the opinions at the trial court level, the Third Circuit Court of Appeals level, and the Supreme Court level. There were some head notes. A case head note is a brief case summary. It's right when you start reading. That is a head note. A brief case summary at the beginning. At the very beginning of a case. So we saw those at the very beginning of the case. And it's helpful in determining quickly if a particular case is of interest. So it just kind of gives a high level overview of the case, a high-level overview of what happened in the case, the issues and whatnot. And they're inserted by the court reporter editors. So West, Lexis, Checkpoint, CCH, they're not part of it. They are editorial. They're editorial in nature. They're not actually part of the official opinion. They're not official. And that's really all it is. Okay, we've got one more question. Question 47, and this one, we're going to be doing the same thing as question 45. I'm going to move this down so we give ourselves some more room because we're also going to be doing some different colors and whatnot because I'm really into this. I love looking at cases and a citation and seeing what exactly you can learn from that. So by using only a citation, state which court issued each of the following decisions. Also, please provide any other information that can be determined from a citation. So first is Douglas, Christopher, TC Memo 1994, 519. We're going to start with that by the black Keller. So that, of course, is going to be a tax court. Now, let's go down here. I'll start by just put number 1, if you want to put a 1 next to this. So Christopher Douglas first name Christopher, last name Douglas, is the taxpayer, also known as my apologies, getting ahead of myself there, the petitioner. Always the petitioner in a tax court case. The commissioner of internal revenue, which is a representation of the government, is the respondent in a tax court case. So that is, in a TC memo, we don't put that. We don't put the second party like that in an official citation. So we just know that Christopher Douglas is the taxpayer, and of course we know the IRS is the other party because it's a tax court case, implied. So the TC memo, that is the official reporter for tax court memorandum decisions. For memorandum decisions. And remember that memorandum decisions are binding. They are binding. It's the tax court summary opinions that are not. And we're going to see that one in the third one. The 1994 is the year the case was decided. And the 519 is the case that year. And that's really everything you can conclude from that specific thing. It's not the page number of any volume. It's the case that year. Let's go on now. Let's go to red. So let's do blue. Let's do yellow. So 2 is Takaba versus Commissioner, 119 TC 285 2002. Okay. We know that Takaba is the taxpayer. So TP for taxpayer. And again, the taxpayer is always the petitioner. We know that Commissioner is, of course, IRS Commissioner. And that is the respondent. Remember that the commissioner is always the respondent in a tax court case. So if you ever find a citation in an appeals level with the commissioner in it, that means it started at the tax court. And most of them that deal with tax issues do start at the tax court. So next, we've got the TC. So the TC, I always go to that next because it helps us understand the reporter, is the official reporter for regular tax court cases. Regular is key, which the regular case is more authoritative than the first case that we saw with the TC memo. Even though the TC memo is binding, this one's also binding, but it's more authoritative. Now notice there's nothing in the citation that says en banc, which means it was heard by one judge. So one judge heard this. There's no en banc in the citation, which means the entire court would have heard it. So the 119 and the 285, of course, are going to be, 119 is the volume, 285 is the page that starts on, and then, of course, 2002 is the year decided. All right. Now, we're going to go to green for Botts Roy R. And by the way, one thing with the citations where it's not two parties like the TC memo or TC summary opinion, sometimes you'll have a letter for a middle name. That's fine. And how you see the citation here is how you would do that. So earlier, we had the citation with the TC memo. I didn't ask you to do a middle initial, but sometimes you'll see that, and that's exactly how you would do that. You just put the middle initial capitalized with a period after the first name with a space or space. So it'll be last name, comma, space, first name, space, middle initial, period, comma, and then you put the citation, TC memo, TC summary opinion, just so you know, if I did give you that. But that, I try not to do the middle initial. So this is, of course, Roy R. Botts, we'll just put that, Roy R. Botts is the taxpayer, which again is the petitioner, always petitioner. The respondent, of course, is the IRS. It's not in there, but it's always going to be the commissioner of internal revenue is respondent. It is a TC summary opinion. So that means that it was a small tax court, I should say a small procedure or small claims. It's referred to as both small procedure or small claims case. So small procedure tax case or a small claims case, either one, you can use those. And the idea here is that it's a TC summary opinion. That's how you know that. And it's not binding on anyone other than the taxpayer. Also, they could not appeal. We know that. They could not appeal. You know that from the citation. So that's going to be the end of this. That's the last stop. Now, the 2001, it's very similar to the TC memo. Is the year decided. And 182 equals the number of case that year. So very similar. And then we've got our last one. And I'll do that one in blue. Greenhouse versus U.S. and give myself some more room here. So I'm going to move this down. Greenhouse versus U.S. This one, we're going to see. So Greenhouse versus U.S., federal supplement, and we've got SDNY, which I mentioned earlier, 1991. Okay, so again, the first question is, what court heard this? And remember that number 1 and number 2 are the tax court, right? Remember we saw number 1 was tax court, number 2 was tax court, the regular tax court. Let me write those down on those. So number 1 was a regular tax court case. It was in the regular tax court, which means it can be appealed. Number 2 was also a regular tax court case, but number 2 is the official opinion, the official tax court opinion. Number 1 was a memo. They're both binding. Number 3, though, is a small tax court case or small claims or small procedure tax court case. Again, all refer to the same thing. This one, based on these two things together, the federal supplement, first edition, and the SDNY, which means Southern District of New York, together you know that's in the district court for the Southern District of New York. That's where the case originated. Okay, let's look at the parties. So Greenhouse is the taxpayer. And remember, in district court cases and U.S. Court of Claims cases, they're referred to as plaintiff. They are suing the government. They're for a refund. So they are the plaintiff. They are the plaintiff here. Of course, U.S. is the defendant. Now let's finish strong and talk about the FSUP. So the FSUP is the official reporter for the district courts. Official reporter. Remember that there's FSUP 2D, 3D, and it's going to go into the future increase. The 780 is the volume. 136 is the page, of course. And then it was decided in 1991. And that concludes everything. All right, that concludes everything, right? We can go through all these things, and I really recommend you go through, especially the case citations, because you learned a lot. You learned a lot from this discussion. And all these questions. It's very important to help you understand the judicial source of tax law. As you can see, it can be quite challenging, and there's a lot of stuff to know. And there's even more. But this is going to help you with the fundamentals in terms of tax research. All right. Hope you've enjoyed this. Please make sure to watch my other tax research and other tax videos.